Good evening to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss an important case law on Section 304, Clause 2, IPC, Indian Penal Code. Normally, even the judges also, they will get confused in certain instances whether it is murder or whether it is culpable homicide not amounting to murder. It's not that easy to differentiate. Every case depends on its own facts and circumstances. So the trial court and the high court also opined that it is a case of murder, whereas the Honorable Supreme Court of India held that it is coming under the purview of Section 304, Clause 2 of the Indian Penal Code. How? Let us see. This is relating to the case Kiran Yadav Vs State, that is National Capital Territory of Delhi. So you can read the case as Kiran Yadav Vs State within brackets NCT Delhi. Criminal Appeal number 2038 by 2022, decided on 23 November 2022 by two judges bench, Honorable Justice A.S. Bopanna and P.S. Narasimha. Right. So please remember only 2 points. Since there is no premeditation and since as husband he took her to the hospital, so the incident occurred only at the spur of moment. So culpable homicide not amounting to murder. If you go to the facts of the case, actually on 14/10/2010, on 14/7/2010, the appellant, that is Kiran, he has assaulted his wife Kausalya Yadav in their matrimonial home. Actually, they were married, they were having a kid. The daughter is also aged about 7 years, and there was a wordy duel between them in which the accused or the appellant, he got wild and he beat her. She fell down, and the incident was seen by the child witness, that is the daughter. Actually, the house was bolted from inside. She tried to open the latch of the door, but it is not possible because she is a tender age, 7 years girl. She could not, height is not sufficient. She raised hue and cry. The neighbors, Sunil and Sanjay, they also came there and saw the incident. So immediately they shifted her. That means even husband also was there. Along with the husband, that is Sunil, this Kiran Yadav and others shifted to the hospital. But of course, she has succumbed to the injury caused by the accused. Therefore, a case under Section 302 IPC was registered against him. Right? The trial was conducted. The trial court and even the Honorable High Court also considered the evidence of the child witness, and they were given conviction, that is life term. Here, please remember how the evidence of a child witness is taken. You know, according to Section 118 of the Indian Evidence Act, the court can record the evidence of any person, maybe an aged person, maybe a child of tender age. Only the test is that actually they will test the intellectual capacity of the person. What is the intellectual capacity of the person? His capacity is whether he can understand the questions or not, whether he can give the reasonable answers or rational answers or not. So the judge will put a couple of questions, and if he is satisfied that this man is able to answer properly or rationally, then he can record the evidence. But in number of instances, I told you, child witness is a dangerous witness. Child witness can be tutored. So that's why whenever the children get abducted, they will be telling you so many stories. పిల్లలు ఇంట్లోంచి పారిపోయి మమ్మల్ని ఎవడో కిడ్నాప్ చేశారు తీసుకెళ్ళి అన్ని బోర్డని అబద్ధాలు చెప్తుంటారు. అంత మాత్రం అబద్ధాలు ఉన్నాయి. ఎవిడెన్స్ ఆల్సో, yes, the evidence will be taken into account. Here she has clearly stated that Yes, my father, but my mother. She fell down. She received injuries. I tried to call the neighbors. They also came. Later, my father dressed up and immediately took her to the hospital. Of course, she died. So, even though the trial court and high court held that it is a case of murder, Honorable Supreme Court of India held that there is no premeditation to cause the death because the incident occurred a spur of moment. So the accused or the appellant Jai Kiran realized his mistake and took immediate steps to shift the victim to the hospital, but unfortunately she breathed her last. So please remember, the actually conviction given under section 302 of the Indian Penal Code has been modified under section 304 clause 2 of the Indian Penal Code. Clause 2 means 10 years punishment. Already he suffered 12 years punishment. So enough is enough. Therefore he is sent away from the jail. Since it is already 12 years, so enough is enough. Therefore he was asked to be released. So this is the twist in this particular case. So please remember, in view of the Honorable Supreme Court of India, this is not a murder. This is only a case of grave and sudden provocation which occurred at the spur of the moment. And second important point is, so the husband acted like husband even though he is the accused. He took precaution immediately. He took her to the hospital. No doubt, as a husband, he did his job. Therefore, a leverage or a considerate view was taken and he was released. Very good judgment. Please read it and enrich your legal knowledge. With this, I am stopping. Thank you very much.